All right, good morning, everyone. Tuesday, May 5th, a little after 9:30 a.m. We are picking up work with a continued conversation on S 323, an act relating to miscellaneous agricultural subjects. After all the testimony and conversation last week, council has honed in some language for us to review and consider. It's addressing a couple of the opinions and buckets we heard from stakeholders in and around the hemp sector. So with that, I'd like to invite council up and run us through the words on the page. Good morning, sir. How are you?
Good morning, Bradley Showman, Office Legislative Council. And I just want to remind the committee that I should be on the Senate floor ASAP.
Okay.
So I am going to have my phone out just in case someone pings me. And so let's walk through the language. So we are on draft 6.1. If you have draft 4.1, just look in the bottom and to make sure when it says VT Ledge, there's a V6 at the very bottom. And then that's the most up-to-date version. I just forgot to update the draft number when I sent it last night. So if you have 4.1 at the top, just double check that there's a 6 at the very bottom in the footer.
6.1 is posted on our page.
6.1 is posted on the page. Thank you. So we'll look on page 2, line 12. And so this is adding permissive rulemaking. So it's not mandatory rulemaking, but it's permissive rulemaking to establish sanitary requirements for licensed processing facilities. And I did some research in this and conferred with a couple of colleagues, and because often the Vermont Department of Health is the one that would establish sanitary requirements for processing facilities, and these are you're processing it into an item for human consumption. However, we've been told that the Department of Health does not regulate anything related to cannabis, and so that they won't go in and touch those things. And so having this rulemaking in here is kind of a bootstrap approach. We think that there might be authority elsewhere for the Cannabis Control Board to establish sanitary requirements. This is kind of a bootstraps approach that would enable them to do that. And chatting with the control board briefly, we might also want to consider storage facilities for products in addition to just processors. But that is language in here that would enable some sanitary conditions. Moving on to the next change, these are all highlighted in yellow for readability. We're on page 3, line 10. So this is a section concerning fees. And what this proposes to do is to give the board some discretion to issue longer registrations.
Is it no? Thank you, Siri.
The board may issue longer registrations and prorate at the same cost per year for products it deems to be low risk and shelf stable. And so just to kind of enable a longer registration period, but prorating the cost over that period of time. And the products may be defined and distinguished in readily accessible published guidance. One thing I want to flag for the community is that guidance doesn't go through the rulemaking process. The rulemaking process is a process in Vermont law that is the process that's there to delegate legislative authority to determine what rules are and things of the sort. Following that process gives a rule the kind of presumption of validity that is a lawful delegation of authority. Delegating to published guidance is less secure in that way. It doesn't have to go through public notice and comment, but that is a policy choice. And we're looking at page 4 and sections 23B. This is what this purports to do is to define an unregistered product, and we would kind of try and perhaps massage that language a little bit better to kind of get at what we're talking about a little better. But essentially what this means is unregistered hemp or unregistered cannabis products that are required by state law to be registered with the Cannabis Control Board. And then we're jumping down to number 2, subdivision number 2 at the bottom of page 4. No person shall cause unregistered cannabis, unregistered hemp, or any unregistered product derived therefrom, purchased by mail through a computer network, telephone network, or other electronic network, to be shipped anywhere else other than a licensed cannabis establishment in the state. And so this would kind of criminalize or penalize with a civil penalty shipping cannabis into the state, cannabis or hemp products into the state that are not registered. And so to give the AG, that was these sections, give the AG kind of authority to enforce that the same way that they do for tobacco products. We think, after having done some research on this, we think this language would fit better in the cannabis subsection itself, as opposed to just nestled under tobacco. It's nestled under tobacco, and the Cannabis Control Board might be able to testify directly to this, but based on my knowledge, they've been conferring with the AG's office, and the AG's office says, okay, well, this is how we do it with tobacco, so maybe we could do it the same way with hemp and cannabis products that are being shipped into the state to provide these penalties and things of that sort. So it's trying to kind of piggyback something that already exists, but it having it nestled under a tobacco subchapter likely doesn't make the most sense in terms of readability and followability for the statute. We want to put it into the cannabis provisions.
And that's with the Department of Liquor and Lottery being a portfolio within our jurisdiction, like we've had testimony and conversations in and around those internet sales that pertains to both tobacco and alcohol over the years. So I think that personally makes a lot of sense to have it a paralleled and uniform approach. So yeah, no, putting that into this function within that same structure, I think it's logical. Right, and go.
So this is not the place for that language, is what you're saying?
Ideally, it would go into the cannabis subchapter in the same title. You know, if I think that is a policy choice. You know, if the AG is saying that it's easier for them to enforce this information, enforce these provisions under tobacco, you know, that's a policy choice based on kind of feedback from those folks. You know, we think from a readability perspective, it might make sense to mirror this in the cannabis subchapter. But that's a policy choice.
And I mean, I guess like your question, Representative, is like, does it live in cannabis chapter, does it live in tobacco chapter? Like, I guess in my mind, like, as long as it's known to exist by the AG's office, it's something that falls under the same sort of structure. And I just asked Nick to try and get Todd from AG for us to offer anything like one. Yep. And then I think one of the other final footnotes, and I know you're on.
Sorry. Yep. Yes. Yep.
Passage it.
Yep. I
Cool.
have a note here for myself.
Excellent. Questions from the committee right now? I know I had this down for us to take a position this morning, but the goal is right now to take this up at 1 o'clock again to give us time to like marinate on the language. Because there are some changes to this, and I realized it just got dropped in boxes a short time ago, so I want to be conscious of that. So questions for council right now before we release them to the upper chamber?
No.
Seeing no hands. All right, thank you, sir.
Thank you very much. I appreciate you all.
So I see some representatives from the CCB here, but other representatives from stakeholder groups. Not to put anybody on the spot, but thoughts about the words on the page from stakeholder group? No.
Happy to just kind of give you my concluding thoughts.
That would be, I mean, you're here.
Okay.
Yes. You're here. We got 16 minutes.
All right, I'll try and speak quickly. So I really appreciate, James Pepper, Chair of the Cannabis Control Board. Really appreciate you all taking a second look at this. I just want to reiterate what a difficult situation we're in with this legislation. There are a lot of great hemp processors in the state that, even in the absence of regulatory oversight, have been voluntarily holding themselves to a very high standard. I've toured the Clean facilities. I've toured the Sam Belavance's facilities. Even without that kind of verify aspect, they have been doing a really great job, holding themselves to kind of CGMP standards and all the rest of it. But there are thousands of hemp processors around the country that have been pushing the envelope on hemp for years and have found that no one's pushing back, not the DEA, not the FDA. not the TTB, not the state departments of health. And they have become more and more brazen about the products they're making, the ingredients that they're using to make those products, where they can sell them and to whom, what's on the label, and the fact that they are not subject to state or state regulation or tax structures. So with respect to hemp products, we really are back in kind of pre-1906 when the Pure Food and Drugs Act was passed. That's where we're living in with these products. And why do I say that? Well, I mean, Oregon, they were setting up their state reference lab on the cannabis side. So the Oregon Liquor and Cannabis Control Board just started grabbing hemp products from wherever they could find them. They tested 50 hemp flower products and 50 edible products. And I submitted the report to Nick for posting today. The mislabeling and no age gating were almost table stakes for all of them. 88% didn't require any sort of ID to purchase them. 75% did not have an accurate label. They mischaracterized the amount of THC was in them, the amount of CBD. It's really important when you think that people are potentially consuming these products and hopping into a car, or consuming these products thinking that they don't have THC in them and then they need to pass a drug test for their work or some other reason. 52% exceeded the per package THC limits, both in per serving size or per package amount. 56 had synthetic cannabinoids in them, which we have very little knowledge about their kind of human impacts, but also they usually belie that someone did something wrong in the conversion process if they have synthetic cannabinoids in them. So it's really kind of the Wild West when it comes to hemp products. So this bill attempts to thread a very delicate needle between those two realities, and in the context of incredible uncertainty at the federal level. When the bill that closed the hemp loopholes first passed in November with a 1-year delay, my first call was to the chair of the Senate Ag Committee, who had been looking at hemp legislation, and asked them, shouldn't we put a pause on any sort of regulation until we know whether these products are going to be considered cannabis at the federal level, regardless of where the THC is sourced from, or if they were going to continue to have this bifurcated hemp and cannabis situation. And, his response was, let's move forward. These folks need regulation regardless. And we'll just kind of make this bill as flexible as possible to accommodate whatever happens in November. I have a strong feeling that there's not going to be a change to that federal definition of hemp because, it would require bipartisan support in Congress. There was bipartisan support to close these hemp loopholes. In fact, there was 39 state attorney generals signed on to a letter saying, please close this. They sent that in October and it was closed in November. So to overcome the amount of bipartisan support in order to overturn the fix, to me, is just unlikely to happen before November. And it would have to raise to a priority in Congress to actually do this. And there's a lot of other things going on. What I think is a much more likely scenario, because we're already seeing the Trump administration do this, is to reschedule all products containing THC, whether they're hemp or cannabis. So that fixes that disparate tax problem, that 280E problem. So everyone's going to be considered a marijuana company, whether you're making hemp products or cannabis products. But you're not going to have those, that terrible tax situation that people find themselves in. So that process has already happened. So the Trump administration, without any of the process that's required under the Controlled Substance Act, through an obscure treaty provision, just rescheduled all medical THC products. And of course, there's no such thing as a medical THC product. There's adult use products that get sold to medical patients. Do those become medical products? No one knows. They didn't tell us in this order. So, but then they sent a hearing to do an expedited rescheduling on June 29th. So they may just reschedule all products containing THC on June 29th. And then, what I see happening, because frankly, there's some kind of, touching on this in the executive order, which is he's going to direct his attorney general to say interstate commerce between two legal states, so long as the sending state and the receiving state are okay with it, is going to be deprioritized for federal prosecution. So I think that's going to be the state of the world after November. We don't know that for a fact, but that's the kind of path of least resistance for these products. And this bill accommodates, this bill is essentially asking us to build a hotel. And we don't know if it's going to have just Vermont residents, a handful of small Vermont operators in them, or it's going to have hundreds of out-of-state companies that are going to try and play in Vermont. And that's why I just think it's so incredibly important to have the flexibility that's built into this legislation right now. The amendments that you saw today try to accommodate the testimony that you heard. It offers maximum flexibility for us to extend product registrations. That was a big concern of Sam Bellavance, and he didn't want to have to register products every year. If he's a CGMP certified facility and he's testing his products and he has a third party accreditor testing his products, why does the CCB need to look at them every year also? And I agree with that. So it gives us the ability to establish standards for certain products that are, maybe have, other third party accreditors looking at them and move them out of that annual product registration. They still have to pay the same fee because I think the Ways and Means Committee would have a problem if we're kind of have the authority to waive fees kind of at our own discretion. But at least they don't have to submit any paperwork to us every year. Both companies also ask for greater enforcement over the really bad products that get shipped through the mail to us. That's what that section around the kind of delivery sales ban, the internet sales, is targeted at. It just piggybacks off of existing authority over illegal tobacco products that get sent into the state. I've had conversations with the Attorney General about this starting last summer. They are understaffed. That division is understaffed. This really would just be a kind of break glass in case of emergency style authorization for really bad products that both our office and their office agreed deserve one of these letters. But I think just given what's happening at the federal level and this push that there's going to be to push these products into any market that will accept them, I think it's really important that we have some authority to at least send a cease and desist letter that has some teeth to it to the worst offenders. And then the sanitary requirements, that was a specific ask from Clean, just saying explicitly that the CCB can establish sanitation criteria because the Department of Health will not, certify a commercial kitchen. That's a request from their out-of-state regulators that want to know that someone is looking at their sanitation requirements. So we thought that it was kind of included by implication or by reference elsewhere, but making it explicit is totally fine with us. And then the on passage, effective on passage, we don't have a problem. We were going to get started as soon as possible. As soon as we knew this bill was signed by the governor anyway, we were going to get started on drafting rules. So, pushing that date up by a few weeks or a month or so is fine. And that's all I have for you, but I'm happy to answer any questions that you might have about this legislation.
Again, we're going to pick this back up at 1 o'clock.
Okay.
Conscious of time. We have a few minutes before floor starts. Questions for Chair Pepper? Cool. All right. I want to thank you, and I would like to thank your attorney for the work on this, as well as the other member of the board in the room. There's been a lot of opinions, thoughts, and concerns to take into consideration here. So I want to thank everybody over in the gallery for their work on this. This has been a lot of moving parts to try and organize with a big, fat unknown landing in November. So I want to recognize that as well. With that, we are offline until 1 p.m. and we're going to pick this up, and then we are going to get also into conversations with the Senate bill and S-278 and act relating to cannabis. So we got hemp and cannabis. Afternoon. All right. Thank you.